Union Judiciary, the Supreme Court. The Supreme Court of India is the highest judicial authority in India and forms the topmost institution of the Union Judiciary. It was established under Article 124 of the Constitution of India to act as the guardian of the Constitution, the protector of fundamental rights, and the final interpreter of law. The Supreme Court ensures justice, equality, and rule of law throughout the country. It settles disputes between the Union and the states, between states themselves, and hears appeals from high courts and other tribunals. It also has the power of judicial review, through which it can declare laws or executive actions unconstitutional if they violate the Constitution. The Supreme Court consists of the Chief Justice of India and other judges, whose independence is guaranteed by the Constitution to ensure fair and impartial justice. Thus, the Supreme Court occupies a central and vital position in India's constitutional framework and plays a crucial role in maintaining constitutional supremacy and democratic governance. Constitution of the Supreme Court. The Supreme Court of India is the highest court of the country and the topmost institution of the Union Judiciary. It is established under Article 124 of the Constitution of India. The Supreme Court is entrusted with the responsibility of protecting the Constitution, safeguarding fundamental rights, and ensuring justice throughout the nation. The Supreme Court consists of the Chief Justice of India, CJI, and such number of other judges as Parliament may from time to time determine. At present, the court has a sanctioned strength fixed by Parliament to ensure effective functioning and speedy justice. Judges of the Supreme Court are appointed by the President of India and hold office until the age of 65 years. The Constitution guarantees their independence by providing security of tenure, fixed salaries and service conditions, and protection from arbitrary removal. A judge of the Supreme Court can be removed only through a special impeachment procedure on the grounds of proved misbehavior or incapacity. Thus, the constitutional structure of the Supreme Court ensures that it functions as an independent, impartial, and powerful guardian of the Constitution, playing a central role in maintaining the rule of law and constitutional supremacy in India. Appointment of judges of the Supreme Court. The appointment of judges of the Supreme Court of India is governed by Article 124 of the Constitution of India. Judges are formally appointed by the President of India, but the process is designed to ensure the independence of the judiciary from executive interference. In practice, appointments are made through the collegium system. Under this system, the Chief Justice of India, CJI, along with the 4 senior-most judges of the Supreme Court, recommends names for appointment. The President acts on these recommendations, and if the collegium reiterates a name, it becomes binding on the President. Qualifications for appointment. To be appointed as a Supreme Court judge, a person must be a citizen of India, and have been a judge of a high court for at least 5 years, or have been an advocate of a high court for at least 10 years, or be a distinguished jurist in the opinion of the President. The Chief Justice of India is appointed by the President, usually based on the seniority principle among Supreme Court judges. The appointment process of Supreme Court judges aims to maintain judicial competence, independence, and integrity, ensuring that the Supreme Court remains a strong and impartial guardian of the Constitution. To be appointed as a judge, a person must be a citizen of India, and have been a judge of a high court for at least 5 years, or have been an advocate of a high court for at least 10 years, or be a distinguished jurist in the opinion of the President. This method of appointment aims to maintain the independence and quality of the judiciary.